Our next speaker is the president of one of our co-sponsoring organizations, the International Association of Penal Law. He's also the Associate Dean at Crichton Law School, a very old friend and colleague, and he's here every year to present the awards for the best book in international criminal law and the best article in the field. I now present Michael Kelly.
And I'm told I can take you to our website. Here we go. Let me tell you just a bit about the International Association of Penal Law, or as we like to refer to it, l'Association Internationale de Droit Pénal. Everything sounds better in French, right? We were founded in 1924. We're one of the oldest scientific associations and the oldest association of specialists in criminal law. Our headquarters is in Paris. The association enjoys consultative status with the United Nations, and every 5 years we have an international congress, the last of which was in Istanbul, Turkey, and Michael and I both attended that as delegates from the U.S. section, and one of the most contentious issues there was the further definition of universal jurisdiction, which will partially be the topic of our first panel today when we discuss the Eichmann trial. The U.S. National Section of the International Association of Penal Law is very active and has been for a number of years. One of the things that we do is we seek ways to co-sponsor events like this that deal with subjects that we're interested in. And we also, every year, honor the most outstanding book in the field and the most outstanding article in the field of international criminal law. And it's my honor today to present those two awards. First, the outstanding article in international criminal law award this year goes to Michael Newton for his article, Evolving Equality, the Development of the International Defense Bar, which appears in volume 47 of the Stanford Journal of International Law. Michael, will you come down and receive your award? Congratulations. The Book of the Year award is a book that comprises all of the contents, the negotiating history, the draft, and the commentary for a new comprehensive global treaty on crimes against humanity. This is one of the missing elements in international criminal law, is a comprehensive convention on crimes against humanity. And Layla Sadat, who has spearheaded this project from Washington University in St. Louis, collected an amazing array of specialists in the field to help pull this together. And we were very proud to co-sponsor this effort, which culminated in the final draft that was talked about at the Brookings Institution conference last year. She has edited a volume entitled Forging a Convention for Crimes Against Humanity that contains the draft language. And we are now ready at this point to move forward with trying to get this treaty adopted. It's a very ambitious project. While Layla is not here to accept the award today, we do have 4 of the contributors to this volume who I would all like to ask to come down and receive the award on her behalf. Richard Goldstone, if you could come forward, Michael Newton, Michael Scharf, and David Crane. If you could all come down and accept this award for forging a convention for crimes against humanity. Why don't you turn around for a photo op? Michael, jump up here on the
video?
podium.
I don't know if there's a photo op.
Jump up there on the podium.
Take it over to my side. All right, that's your photo op. Good. Thanks. All right, thanks. Thank you.
Okay. And with that, I'll turn it back over to Michael Scharf.
Thank you, Mike, and thank you again to the International Association of Penal Law. Now, there is an organization who is more associated with this conference than any other, because the conference is actually International Law Weekend Midwest. This is the conference of the region for the American branch of the International Law Association, and we are very happy that we have the president, newly elected, of that branch to speak to us this morning as our morning keynote speaker. And let me tell you a little bit about her as we prepare to hear her remarks. Ruth Wedgwood is currently the director of the International Law Program at Johns Hopkins University's graduate program in international law. She started her career as an assistant U.S. attorney, rose to the level as an advisor to the Department of Justice. She has been a professor at Yale. She has been the U.S. expert on the Human Rights Committee. She is a prolific author and has done more than most people, maybe than anybody, to push the field of national security law and to leave her imprint on that field. And we are very happy to welcome Ruth Wedgwood today. Ruth?
Back to the...
Oh, yeah, do you know how to do that?
I don't.
Let's try. I don't think that was it.
I don't know how to use that.
I'm just trying to get to, you have a slide here of you.
Oh, no. Shut that down.
Well,
Oh, God, no.
here, we'll go to,
No,
no, we'll go to,
Take that off. That's the
we'll
worst
go to,
picture you ever
we'll go
took.
to, sorry, we'll go to this picture.
That's hideous.
That's all right, we're just trying to introduce you. And now, Tim, how do I make it big again? What? Hit F5, that's right. Yes, you may, I'm sorry. There you go.
Thank you. Anyways, it's great fun to be here. That really is the worst photograph I've ever taken, I think. I would have paid you off. I would have paid you off to not do that.
Don't push that button.
Anyway, it's great fun to be here with so many people that I know and love and respect, and including Judge Goldstone, who I've known since he first came to the U.S. really 20 years ago. And may I become intimate for a moment? I sent Judge Goldstone his first black law clerk, who was a Yalie, Vernon Grigg, who had a wonderful time with the judge in South Africa, both working for the South African Black Bar and working in Judge Goldstone's chambers, and has since grown up and become successful. And so many people here are wonderful colleagues from what is at times the fairly contentious enterprise of international law. It sounds so vapid when you tell a layperson that you do international law. They don't know what it is. But as we all know, it touches on so many areas of deep moral commitment and contention, so many strategic problems. It's hardly dull at all. I want to congratulate Michael, really, and the dean and everybody else here for having built CASE into such a center of international law debate. And I also, if you'll forgive me, want to thank Nancy Pratt for being a splendid organizer who really was very solicitous and helpful in all aspects of the conference. And I have to note, for the sake of family, that my late husband had family ties here. His father taught at Case Western Peds for many, many years, and I take it that actually the Case Clinic is now the biggest employer in town. So this is still a great medical center, which means a law and medicine program here has to be something splendid as well. And this is, as Michael said, International Law Weekend Midwest. We're going to do Southeast and Southwest, so don't get too big for your britches. But it really is very nice to have the International Law Association have some occasions in which it can strut its stuff. It's not very well known in this country, to be perfectly honest, but it's the International Law Association. It's a little different from the American Society, at which Europeans occasionally attend. But the ILA, founded and centered in some ways in London, is the equivalent of the American Law Institute, which we all know and cherish. ALI is the tripartite group of judges and practitioners and academics that debate and give birth to things like the restatement on agency and contracts and torts and foreign relations law. And ILA is the ALI, not just in a flip of the letters, but it does negotiation and preparation of proposed texts and treaties through meetings of international groups of international lawyers from around the world. So it's a very different way of doing international law. It gets Europeans and Asians and Latin Americans and North Americans together to try to hammer out texts that are viable for using in private international law and public international law alike. So if you haven't joined, I welcome you to do so. It's www, here I'm getting like Michael Scharf, www.ila-americanbranch.org. $70 a year, but your dean will pay for it. And it gets you invited to wonderful conferences all over the world, but more to the point, it makes you eligible to take part in both the US and the London-based conferences, which are of some moment. If you look at the International Monetary Law Committee, say, you find major people from the players of the banks and the Fed. It makes a large difference in the substance and texture and expertise of international law debate. So if your dean will float a second membership, I urge you, welcome you to do it. And then we're going to, of course, have our major splendiferous annual International Law Weekend, which happens every October in New York, this year, October 20 to 22nd, which brings together UN diplomats and senior practitioners from firms in DC and Washington and New York, and academics from all around the world. It's a very nice gathering. It's been going on since as long as I've been teaching international law. And free for all students, and Case might sponsor next year, which would be very nice. Anyway, I have lived most of my life being ornery and contentious. Must be my mother's Western background. And so I'm not sure I agree with the premise of the conference, is international law in crisis. Or did you say, was that a question or a statement? It's a question, okay. I'm not sure international law is in crisis. The world's in crisis. And the ability of international law to contribute to its resolution, the resolution of its problems, may be halting and frustrating. But I think actually, as a field, certainly, international law is healthier now than it's been in a very long time. There's more debate. You have the American Journal of International Law, you have the European Journal of International Law, you have the ILA and the ASIL and the EGIL. It's not a specialist area anymore. Everybody who teaches anything, family law, trade law, commercial law, has to go international. It's very different from when Michael Scharf and I were law students. Everybody now is an international lawyer. And American judges have begun to hire law clerks who know the stuff, sometimes a bit naively. A little international law can be a dangerous thing if you don't really know the field and don't understand the political processes that give rise to various texts. One of the problems of evaluating UN documents often is you don't, if the person reading it, just a facture type, it looks like something canonical, doesn't understand what the makeup and dynamic of the group is that gave birth to that text, then they can make the mistake of treating all texts equally and may not realize how politically driven some kinds of organs of the UN and other international organizations are. So having a certain sixth sense or seaworthiness of evaluating texts is something that both judges and their clerks may not yet have. And I worry that because most international lawyers live their lives largely in the academy, even we may lack it. That's why I think it's very important to get out there and get dirty and take part in a bit of rough and tumble of the politics of international organizations, if only as a participant observer, a kind of a Margaret Mead anthropologist, so you know what it means. And can evaluate how you should read the text. Every American businessman now needs an international lawyer, so it's, again, very good for the growth pattern of your program and others. Every employee, in this town particularly, has to worry about the international arena as his job goes to China or Malaysia or Sri Lanka or India and will never come back, and figuring out what to do as a consequence. And clearly, if Thomas Jefferson were alive right now, he'd be looking abroad. He did already, to Paris, of course, but the role of the U.S. in North Africa and elsewhere in the world in trying to use our now less sumptuous power in an effective way and facilitating good solutions to human crises is something that is very much a moral engagement of the U.S. and always has been. But let me just make the larger claim. I think, strangely enough, law generally works best in the routine case, in the buying and selling and leasing and purchase. And in these extraordinary cases, the law can become unclear and contentious. And in a way, I think, for those of us who are trained largely in the legal academy, law comes to seem quite naked and insufficient. And as I lived my rather heterogeneous life, dabbling a bit at DOD, dabbling at the UN, dabbling in the criminal justice world, it certainly became clear to me that to really do international law properly, you need to know a lot about politics and power and strategy and the use of force, as well as what methods of persuasion are likely to be effective. That it's not simply a read-only CD-ROM or write-only CD-ROM. It really is a very robust political process in which naivete can be unrewarded, shall we say. And I worry about the tradition in American law school teaching where people enter the academy as 26-year-olds or 8-year-olds after clerking and live a cloistered life. Whereas in the old days, the good old days that never existed probably, but someone like Lou Henkin would come to teaching after 20 years out, long career at L, at the State Department, and someone like Oscar Schachter, was it Schachter? Yeah, Oscar Schachter was at the UN until he was 60 years old, and then crossed over to Columbia full time. And that kind of Fingerspitzgefühl, that feeling for how the system operates, is something that, if it's lost, will make this into a very hollow field. You certainly can't do international law without, I think, some political savvy and some sense of how you go for the jugular strategically in getting results that one should want. Examples of things in the institutional world of international law that aren't going so well at the moment, not through their fault, but through circumstance. The Lebanon Tribunal. I think it was marvelous to have a tribunal organized to investigate the outrageous assassination of Rafiq Hariri in Beirut. I went with the Jimmy Carter, I know some people think that's funny that I would go with Jimmy Carter, but Carter led a very worthy election observation campaign in June of '09, and it was kind of a Beirut spring. There was great hope that a coalition government could be formed. I went up to a little area near Tripoli, Maronite Christian, learned for the first time about something called not choice of law, but choice of confession, that what law applies to you depends on what your mama was. And you can't have an interfaith marriage, and you can't run for office unless you're the right religious confession in a particular district. But there was great hope that the kind of Levantine quality of Lebanon would be restored. It's liberal Mediterranean culture. And that the tribunal would be able to both bring charges and make them stick. But the role of Hezbollah, sponsored by Syria, sponsored by Iran, has meant that it has been and will be for a very long time to come impossible for the Lebanon War Crimes Tribunal to execute its warrants of arrest. And that's one example of how you just can't, in real life, do international law with any teeth unless you can both decrypt and somehow improve the political landscape in which you're seeking to operate. The Yugoslav Tribunal, in which Judge Goldstone was the first prosecutor and did a bang-up job, also had its political constraints. They needed NATO to execute arrest warrants, which NATO was reluctant to do for a very long time. They needed NATO for security and exhuming mass graves. When it came time to look at the issue of the U.S. operation in Kosovo and NATO's allies, the NATO allies that took part, it put the Yugoslav Tribunal in a very delicate situation where the very organ it depended upon, NATO alliance military forces, might itself be potentially subject of investigation. It was handled, I'll put it this way, adroitly, but it showed that it really is very hard to operate in some kind of platonic heaven. And the difficulty, I think, in the Yugoslav Tribunal ultimately, and this is said as an old Southern District of New York prosecutor who came to value facts and the centrality of facts in a way that I was not taught at Yale. At Yale, we were above facts. We did theory. But any trial lawyer, any trial judge knows facts are everything, and that they're elusive, and that they are complicated, and they shift on you like quicksilver, and that I used to use a phrase when I was a prosecutor, you have to suborn the truth, because it's usually extremely awkward and detrimental for any person to go out of his way to be a stoolie, to testify against another person. It leads to violence, economic retaliation, humiliation, the rupture of friendships. So finding facts is I think that's a vocation that law schools don't sufficiently value, and that, in fact, for the teeth of law is as important as any put any particular theory, any particular talent in spinning out theory. Fact lawyers, I think, are the core of the actual application of law. And the other thing that's key is just knowing how to frame I don't want to call it a political project, but a temporal project that makes sense. I think the one sad part of the prosecution of Milosevic in the Yugoslav tribunal was that it was done as a narrative of all 3 episodes of Croatia, Bosnia, and Kosovo, and therefore it took too long, and therefore the judge died and Milosevic died, and there was never a verdict. So the old army slogan, keep it simple, stupid, kiss, or the old saying of Judge Pollack on the Southern District of New York trial bench, I'll give you 2 hours, young man or young woman, to try your case. Oh, but judge, I need 2 weeks, 2 hours. Put on your best witnesses. You don't use a trial as a historical narrative. You're looking for a sufficient proof for the legal elements at hand, that for the future of war crimes trials is absolutely essential to take in mind. One of the lessons of UN politics, too, was that every coalition has a half-life of about 5 years. Whether it's UNSCOM, make it 2.5 years. Full life of 5 years. Whether it's UNSCOM, whether it's support for tribunals, these coalitions tend to break apart, if only because their adversaries become quite skilled at picking away at the alliance through various inducements. And therefore, one of the key elements of being a good lawyer of any kind is knowing how to do something elegantly, with great fidelity, but quickly. I won't even remark about Bush v. Gore, how I think perhaps that the Democrats also went for the capillary instead of the jugular in their challenge to the electoral count in Florida, and might have had a different result if they had not been trying the case in a way that was going to take forever, because someone has to be president finally. War in Kosovo shows some of the same challenges for international institutions. I think, I will confess I supported the NATO intervention. In retrospect, I'm not sure I would. Because of some of the fact-based allegations against Belgrade were not as well documented as one had hoped. Operation Horseshoe was never documented. It was never clear that Milosevic really did intend, come what may, to have mass expulsions. But in any event, it is clear that it was very hard to be a Kosovar Muslim, as it was very hard to be a Kosovar Serb. But since that time, in the new industry of post-conflict reconstruction with institutions like UNMIK, the UN mission in Kosovo, one also sees the difficulties of governance and how international lawyers aren't as such equipped to do that. It's easy to overthrow a regime, pretty easy, but it's very hard to reconstruct a country. And over the years in UNMIK, although some of the special representatives are my very close and dear friends, including Soren Jessen-Petersen, who's a wonderful man, have been frustrated by both the intractability of the ethnic rivalries and the institutional stodginess, yea, corruption at times, of UN operations. One of the problems at UNMIK has been that the NATO forces were not able or perhaps willing to engage in sufficient control of ethnic violence in 2006, so that the ethnic riots really just reopened all the wounds that had been barely healed over from the intervention in the late 90s. There is mistreatment of the Serb minority in those riots. There's currently terrible problems of corruption. There's violence at the border. There is this kind of half progress in whether Kosovo will be recognized by enough states to function internationally. It will not be in the UN for a while because of Russia. But it still largely has to operate through UNMIK, the UN facade, as its intermediary in many kinds of settings. And the UN itself, and here's something I hold very dearly about the integrity of international institutions, has not addressed issues of conflict of interest. One thing the UN needs to look at seriously and intensely, and needs to be, for this to be done, there needs to be public awareness, is difficulties of conflict of interest in conflict zones, post-conflict zones. A rule so simple and self-evident that you shouldn't go from one side to the other representing different interests on the same issue. There's no such rule at the UN. So you've had lawyers for UNMIK, both in Pristina and in the west of the country go from representing the UN directly to representing the UN's interlocutors, or adversaries, if you will. Go from UNMIK to Thatchy, UNMIK to Hadi Dinah on the same issues. No rule against it. How would you enforce a rule? People in New York asked me. First, you have to have the rule. So I do think that in conflict zones where there are riches lying on the ground, where it's very tempting to make your fortune because the telecom monopoly is open for purchase by brothers of foreign ministers of European countries, it's very important that the international community more severely examine its own integrity in the kinds of rules of the road and behavior that it expects of people who operate as international civil servants in conflict areas. People in the Balkans are very cynical, and it's for good reason at times. And to have people enriching themselves does not in any way improve the governance of a post-conflict area. Very different topic, which I know Michael's going to address later today, Somalia and piracy. That has been a huge challenge for the international community. Law has helped a bit. You have an extraordinary Security Council resolution that allows states that are taking part in the naval flotilla to even go on shore if they wish with the permission of the Somali government. It's quite an extraordinary Somali-backed Security Council resolution which would invite land operations, but no one wants to go because, of course, Mogadishu in 1993 and the prelude to Rwanda's non-intervention and the bad experience on the ground. So there, I think we also see the difficulty of the international community in addressing collapsed states, that there really is no sufficient supply either of military power or, frankly, of interest in trying to reestablish order in states that have really just imploded. And just turning, it's a real potpourri, I apologize for the heterogeneous nature of this little survey, but Arab Spring, clearly NATO was of some assistance to the rebels in Libya in overthrowing Gaddafi, although with a bit more hypocrisy than I would feel comfortable with. Only protecting civilians is very worthy. I think, though, pretty clearly it became a mission-oriented exercise seeking Gaddafi's exit. Not a bad thing, all in all. But it's going to pose another very great challenge of post-conflict reconstruction that may well lie beyond our capacities. Now, on the question of lawyering as a craft, again, I think the three things I'd emphasize, and I may repeat myself a bit here, but one is that we should be more faithful in returning to the old 19th century German tradition of just reporting the facts, ma'am, kind of dragnet versus plus Germany. Because there's a huge temptation in the fluid, elbow-roomed world of international law to make the law say what you want it to, because so much of it's indeterminate, and because there are categories that are open-ended and allow for evolution, dynamic field. But if judges are to take it seriously, I do think that each of us has an obligation, whether we're hired as witnesses or writing a law review article, to give a fair account of the spread and diversity of opinion in the international law field, whether it's John Yoo doing his torture memos or a person writing a article about what has made it into the category of jus cogens, of peremptory law, that is law even without the consent of the state. And that temptation of a kind of call it what you wish, progressive lawyering, dynamic lawyering, law-creating lawyering, it's a huge temptation, but it's one that I think in which least differentiation of one's role has to be clear. One can say what one wishes the law to become, but one also has an obligation to people who don't know better, including judges, to say what is already settled law and not settled law. So it's a field in which I think it requires a kind of self-abnegation, because if your hand's on the throttle, it's very tempting to drive, but it's a field in which judges and others need guidance as they too learned the field. Back to the issue of fact-finding, I do think that international institutions, and here I plead guilty, have to have more capacity for re-examination of their own fact findings. I salute Judge Goldstone for his, I think, intellectual courage in re-examining some of the conclusions of the Goldstone report. I sat on the Human Rights Committee for 8 long years with a lot of hard rock candy and gumdrops to keep me awake and alert, listening to states report on their situations of human rights. And we then drew up concluding observations at the end of each report. Sometimes I worried that we mistook the product for the effect. The UN has a tendency to think that writing a document is an end unto itself. But at times I was also troubled that we had no rule or capacity for states to tell us we got something wrong. We did the report on Korea. I think I may have even been the rapporteur. And then I went to Korea and toured around and met with one of the NGOs that we had talked to, and I'd gotten a small point of law wrong. And we were worried that they were stacking prison penalties for conscientious objectors, one on the other. And it turned out that was not the case. But in a quick session where things are going by quickly and whizzing by with no opportunity for the state to petition for rehearing for something you got wrong, stuff happens. And I do think that there should not be any kind of self-ascription of infallibility that, I see that, I'll stop soon, of infallibility in international organizations, no matter how pressed they are. So too when we did communications, little cases about individuals. We were left only with the papers. We had no oral argument. The ability to actually do the kind of nicety of fact-finding that you would like to have if you really are a fact lawyer was problematic at times. There's also the problem of sharing between tribunals. I was perhaps a little outspoken on this, but when the Yugoslav tribunal had gotten the Serbian wartime documents from the Serb War Council, which would have gone to show Serbian sponsorship of the genocidal acts in Bosnia, those were not available to the International Court of Justice because of promises made when the documents were obtained by the criminal court. And that sort of public display of constrained fact-finding is not helpful to the authority of international institutions. So I do think that, as a general métier, international lawyers need to become much more serious about the way they find facts and think about them. In general, therefore, I guess I would prescribe for any students who happen to be here this early in the semester that if you're thinking of your life in international law, get out there in the world and become the Margaret Mead participant anthropologist. You can't report on your tribe unless you know how it behaves. And therefore, it will behoove both the efficacy of international law and its integrity to do that. And I also do think that international law ultimately needs to admit its dependence on state power, that there's very little that it can enforce of its own right, that you do need states to act for you, whether with military power or with political power or economic power. And therefore that it's not illicit for an international lawyer to also want to know how governments work, how armies work, what the actual practice of diplomacy is, how the various modalities of speech that countries use and what they mean. But there's a funny word in Russian which I can't pronounce, vereme or vereme, it's like truth, the word for truth. But it means the little white lie that everybody knows is not true. And there's a lot of that in international politics. And the ability to, if you will, categorize modalities of speech. Remember that, our philosophers here, that little Austin book, How to Do Things with Words? Is France hexagonal, asks the book. Well, in a sense it is, in a sense it's not. So you really have to be able to categorize what the speech is about and how it's meant before you can estimate the reliance that you should place upon it. So I guess this is all a self-justification of a fractured life. I was supposed to go to the Hague Academy at the age of 7, but I failed to report. But I do think that international law actually will be greatly enhanced if people, and academia too, dare I say, if people get out there and become rough and tumble and see the world in its vulgarity and its violence before they start prescribing rules for it. So thank you for having me.
Professor Wedgwood has agreed to take 15 minutes of questions before we take our break or comments or whatever you want to do. Please come up to the 2 microphones in the front of the room, identify yourself and your affiliation, and then keep your comment or question short, and she will do her best to respond. Don't be shy. This is really an extraordinary opportunity to have a dialogue with the president of the International Law Association.
Honey.
American branch.
Thank you for the very interesting remarks. I'm Hari Osofsky from the University of Minnesota. And I'm curious, you sort of, in saying the deep interrelationship between international law and power, you were, of course, standing, you're at the edges of a huge dispute about how we think of the legal status of international law, and particularly as compared to domestic law. And so I'm curious, especially in the backdrop of Obama's speech and the almost inability of our country not to default on its debts in the last few weeks.
No academic's ever going to retire, by the way.
Yeah.
We're all in 401ks that don't pay.
So I'm curious how you would contrast the rough and tumble world of domestic politics and the intertwinement between power and law in the way domestic law operates right now with that of international law.
So the question really is, does power matter in domestic law as well?
Well, so presumably power does matter in domestic law, but I guess my question would be, often in some of the debates over the limits of international law and what international law does, the claim that international law is deeply intertwined with power gets used as a justification for saying that international law is less law-like in some way than domestic law. And so I'd just be curious, given the rough and tumble of domestic law that we're seeing full out in front of us right now, to what extent do you think that claim about power is a basis for differentiation, and if so, how?
Well, first, just to dodge your question for 1 second, in justification of the remark about the relationship of law and power, I think what radicalized me it was not GWAD. It was watching close at hand when I was in New York in the 90s, Rwanda and Bosnia, and knowing everybody on the 38th floor, Shashi and Iqbal and Kofi and Boutros, and watching the kind of self-justification of not intervening in Washington. I did a debate with Shashi at the Carnegie Council on Ethics and International Affairs a few years ago. We were both feeling very bitchy, and my best line, I think, which he, of course, reposted to, was, if you listen to Shashi at times speak as the spokesman for the UN, when things are going badly, he'd say, when things are going well, he'd say, this is the world community acting. When things are going badly, he'd say, well, my dear, it's just a collection of states, both of which are true. But the sheer fact of having an international organization there doesn't relieve you from the very difficult task of cobbling together an ad hoc, one-time only coalition of states that are willing to intervene in a particular circumstance. And all states have their sensitivities, so you can't ask India to do certain things and Japan to do certain things. So it really requires this kind of retail Fingerspitzgefühl that allows you to figure out where you get the modicum of power you need. Different in domestic politics, I suppose, in the sense that you do have a police force. But we also all understand that you often have to set the scene for a fundamental social change. And Thoroughly Good Marshall, when he was doing civil rights litigation, knew he had to start slow and educate judges and bring them along and create a kind of not to be too radical too quickly, and create a cultural foundation for what was going to be a fundamental change in social practice. So I'm not entirely divorced, but still there is a police force which typically will react to at least palpable violations of the law. So I guess it seems to me international law just requires much more of a fan dance to persuade countries that they should do what might be in their self-interest. And one worries that, again, having the extremely intricate architecture of the UN creates a belief in the automaticity of the mechanism. There's no there. You have to make it work. And it provides you a location, a vehicle, a rhetoric, a legal framework, but it still is patching together the kind of hue and cry. If you go back to English common law in the 13, 14, 1500s, there was the hue and cry, the duty of every citizen to respond when someone shouted robber, the duty to testify. That's why juries were in the vicinage, because the neighbors knew best. It was really much more of a voluntary collective than having Robert Peel's professional police force of the early 19th century. And I think international law is still back in the the medieval period of enforcement. So that's why it has an unavoidable relationship to power. And I guess also one is embarrassed to admit and recognize and therefore legitimize that some states do more than others. Freedom of navigation is something that very few states can act on. Now with China asserting itself in its historical sea, which is a brand new category. One worries that with the US power declining, there's not going to be this sufficient pushback and that China's neighbors are going to be intimidated by it. So it really is a question both of willingness and capacity. And the challenge now, I suppose, is in parallel. The US is economically in dire straits. Well, it's not terribly healthy. And that's going to affect our ability to act as a kind of a Robert Peel police force for common public good abroad. So I take your point. The new professor of law at Pace University Law School.
Can you speak to how to create that cultural fabric and the role of U.S. law schools and perhaps the media, but really the curriculum in trying to do what needs to be done and for the U.S. to play the role that it has played in the past, but struggles to play because many people in the U.S. don't have that basic capacity because they don't have it in the curriculum. A basic understanding of international institutions and some of the legal instruments.
Well, I don't know how you do it is the problem. I think in this, you can't really have a law school clinic in UN politics and send kids off to spend 5 years in Geneva.
Well, the Hague Academy.
Well, that's a very nice little set of seminars, but I guess again, this is all self-justification, I suppose, so most of us do that after all. I suppose partly it's a matter of speaking frankly. When I wrote op-eds in the 90s, occasionally I'd annoy people. It was saying what everybody at the UN knew to be true, but wasn't free to say because they had to stay relatively discreet between the ages of 32 and 62. And at 62, they didn't care anymore. So being frank, sort of a loving frankness. What would a psychoanalyst say about that? Telling the truth to yourself in a way that's not derisive, but is meant to be therapeutic, or at least helpful, didactic. So yes, I do think what the academy, first of all, should do is hire, no, I'm not taking up the cause of that guy who's 62 years old in North Dakota who wants to be hired as a law school professor, although I do think he probably was discriminated against. But the academy impoverishes itself, I think, by only taking kids right out of law school to become professors, because there really is a great deal of craft in the art of law. Law schools lost their intellectual self-confidence somewhere in the 70s. Civil rights movement was largely over. What are we going to do? Law and economics took the stage for a while, but what was lost was what Judge Friendly, my dear old judge, very much held to, that there was a particular art and sensibility and literary nature and what Cook would call artificial reason in being a lawyer. Being deeply learned in the law meant something, including the practice of law. And I don't think law schools value that anymore. They are filled with PhDs who were crossovers in the 60s when there was no job market. They are rather ashamed of being craftsmen. But it's like doing theory of art versus being an artist. How do you teach someone to be an artist? You don't do a theory of aesthetics. You teach them how to sculpt. And I do think that law schools have lost that commitment to, not to make everybody into clinicians, but to say that there's a deeply resonant experience of the world. I mean, Dr. Schneebaum here teaches for us at Hopkins in my little law program. And he's a practicing lawyer. He's a wonderful teacher, just a wonderful teacher. And he can teach kids things about courtrooms and how they operate and how you make a persuasive argument and less is more and how to get to the point and how to really be salient and crisp than any academic, so straight academic. So I think law schools have really cheated themselves, impoverished themselves by losing that tradition of being able to live a double life. Joseph Story, the Dane professor of law at Harvard, was a full-time justice. So I do think this would be a much better way of giving kids at least a taste of the world if you have. Plus, the war stories are always fun in the classroom. But For international law, I don't know, it's harder because it's a very specialized world now. Every institution has its own ethos and its own problems. I can't tell you diddly about the WTO and what's wrong with it. So it really requires, I think, frank reportage by the people who do take part in a way that's respectful, not destructive, but a kind of a Margaret Mead account. You can't teach international law from a book. Well, you can. We do it all the time. But all you do are teaching the basic rules of reasoning, but not the political process that drives the law. So no more than you could be a politician by having read a book about the rules of procedure of Congress. Can you do this? Oh, well, somnolent. I've made you somnolent. But delightful to be here, and congratulations to Michael on a great show.
Thank you so much, Professor Wedgwood, for kicking off this conference. Wonderful speech. We now will have 15-minute break. Please reconvene here or in the overflow room, or if you're watching from TV at your computer, turn it back on at 9:45. We will beginning having two concurrent panels, one that's being webcast live, the other one will be webcast later when it's archived. The first is here, Universal Jurisdiction in Crisis, in the 50th anniversary of the Eichmann trial. There is Eichmann. No, sorry, I got that out of there. And the other one is International Economic Law in Crisis, merely in times of crisis. So we'll see you back here in 15 minutes.